Now, confidentiality. Prudent, and notice here the word prudent, in the use and protection of information. So the word prudent here does not mean that you should fully protect information or you are responsible for every breach that happens to the information. It just says prudent. Do what a smart person would do. Do what another auditor would do under the circumstance. For example, I have clients' information on my laptop. So if I take this laptop and I go out and I leave it in a coffee shop or I leave it in a car where it's visible, somebody breaks in, takes the laptop, opens it up, it has no password, they access the client's files, that's not prudent protection of the company's information. But we all have clients' information on our laptops. So if we have a password on our laptop, our laptop is encrypted. We do not leave our laptop unattended or we leave it in the trunk of the car if we leave the car somewhere. In that case, if for any reason somebody did manage to steal the laptop, did manage to break the encryption, did manage to break my passwords, I was prudent enough in the protection of information. So files, papers, if I put them on the table, on the desk, and somebody sees them, that's not prudent in the protection of information. If I lock them, even if it's a small lock, as long as I did my best to put them away and lock them, I was prudent in the protection of information. Now, prudent in the use is another example, which we'll cover now. I'll give you an example. And the general rule is never to use information for personal gain or to the detriment of the organization. And now here I ask you, you are the auditor of a company that bottles milk for infants. And you discover that the process they're currently using or the package they're currently using is causing cancers amongst infants. You learn of this information, you take it back to the management, and the management will tell you, oh my God, this is a catastrophe. You know what? We have to change our manufacturing process, but this will take 2 years. In the meantime, we cannot do anything because if we do anything, we will be out of business and all our investment will be gone. Of course, we might not be happy with it, so we go back to the board because this is causing cancer to infants. So we go to the board and we tell them this is the case, and the board will say, you know what? If we announce it now, or if we stop until we get a new manufacturing line, we will be out of business. So what do we do next? What would you do next as an auditor? Escalate to the government. See, that's where the question mark arises. And this is where the rule of conduct does not say do not report. It does not say report. It just says being prudent. Now, would you escalate to the government? I don't know. Why? Because some laws, in some countries, you are forced to report crimes. So some laws, if you are aware of a crime, you are obligated to report it. So even as an auditor, if you come to know of a crime being committed, you have to report it. Other laws, you are banned, you are prohibited from reporting on confidential information that you come to learn of as part of your work. So in these countries, you are not allowed to report such information. So in these difficult situations, you would try to make a decision from the heart of the code of ethics, from the core values, and probably, if you're unaware, if you're not sure, seek legal counsel. So what's unacceptable information? An auditor used audit-related information in a decision to buy stock issued by the employer corporation. So acting on information to trade stocks is unacceptable. And I'm starting it because I want to contrast it to another one. Unacceptable. Purchasing stock in a target company after overhearing a company's executive discussion of a possible acquisition. Discussing audit plans or results with external parties. So discussing audit results with external parties is unacceptable behavior. Promise a whistleblower absolute anonymity when they disclose sensitive information to the auditor. Because the auditor may try to protect whistleblowers, they must act on any information received in the best interests of the organization. So if somebody comes to you and tells you, you know what, there is a crime being committed in that department, or theft or fraud is being committed in that department, but I can only tell you details if you promise me not to mention my name. That we cannot promise, because we can tell them we will do our best not to mention your name. But if you tell us about a fraud and we go on audit and we do not find it, we are obligated to tell the board, to tell management that we were informed by so-and-so about this fraud. So if we manage to gather the evidence from alternative sources, we can keep their identity anonymous. But if we could not, we are obligated, because we learned about the issue, to report it to management. So promising whistleblower absolute anonymity is a violation of the confidentiality principle. Bypass the CAE and discuss matters with external auditors. And here is the golden rule that we're going to see throughout. Niroshan, yes, you can report it to the legal advisor in the company, as long as you're within the company. So this is the key here. We are not allowed, the general rules, we are not allowed to report anything outside the organization. Anything whatsoever. Anything we report outside the organization, we need an authority to do so. So either the charter allows us to communicate with external auditors or with outside parties, or the law, the regulations in the country require us to report to them any violations, or we receive or we get management consent on reporting outside the organization. Unless we have an explicit consent, the general rule is we are not allowed to report outside the organization. So bypassing the CA, discussing matters with external auditors, that's a violation of the confidentiality principle, because we're not allowed to, by default, communicate with external auditors. We need authorization. Discussing and or sharing findings, recommendations with auditors from another organization. Notice here, findings, recommendations, results with outside parties is not acceptable under the IIA's Code of Ethics. However, an auditor was subpoenaed in a court of case in which a manager partner claimed to have been defrauded by the auditor's company. The auditor divulged confidential audit information to the court. And this is the general rule. Whenever you see the word subpoena is a legal term where the courts, the judge, ordered somebody to divulge information. And the rule is a court is the law. They cannot request something illegal from people. So if a judge is requesting it, if a court is requesting it, then it is legal. And if it is legal, you have to divulge. So whenever it's a court subpoena, you are allowed or you are required to divulge information. An auditor gave a speech at an IIA local chapter meeting outlining the contents of a program the auditor had developed for auditing electronic data interchange connections. Several auditors from major competitors were in the audience. In fact, this is the mission of the IIA, progress through sharing. But we do not share findings. We do not share results. We do not share recommendations. We share knowledge about conducting audits. So in this case, we're outlining the contents of a program the auditor had developed for auditing EDI. So it's the content of a program to audit. It's not the results. The CA refuses to provide information about company operations to his father, who's a shareholder. That's acceptable behavior. Not acceptable from the father's perspective, but that's a different story. And internal auditors shared audit techniques and or organizational controls with auditors from another company. So we're talking here, we're sharing audit techniques or organizational controls. That is acceptable. On the previous slide, results and findings or recommendations are not acceptable. And finally, based upon knowledge of the update of the probable success of the employer's business, an internal auditor invested in a mutual fund that specialized in the same industry. So notice here, this was acceptable. On the previous slide, based on knowledge, buying stock was not acceptable. What's the difference? Buying stock, the auditor acted upon the information directly. They made the decision to buy or sell. Whereas buying shares in a mutual fund. Now, the mutual fund decisions are made by someone else. This someone else might invest in the company or might not, might sell the company or might not. So in this case, the auditor is not making the decision. The mutual fund manager is. So buying stock directly is okay. It's not okay. Buying mutual funds indirectly is acceptable.